I'm Catherine Pruitt, a board-certified family law attorney and founder of Pruitt Law Group. If you think you may be headed for a divorce, it's important to get your legal advice from a qualified family law specialist, as there's a lot of bad information out there. Today, I'd like to take a few minutes to debunk 3 family law myths in Texas. The first myth is that Texas recognizes legal separation. Texas does not, in fact, recognize legal separation. Even if spouses choose to live apart, the laws regarding the creation and disposal of community property still apply. For example, your income and your retirement account contributions will still be considered community property. If you want to essentially divide your assets and provide that any income moving forward will be separate property without getting divorced, you will need to have a partition agreement drafted. In addition, moving out of the marital residence and/or filing for divorce does not give you a license to date since you consider yourself separated. Engaging in a sexual relationship while you're still married is still adultery under Texas law. The second myth is that if property is in your sole name, it is your separate property. A related myth is that if you purchase an asset during the marriage and put one of your relatives' names on it, then it would not be considered community property. Neither of these statements is true. While you do have the right to the sole management of property in your sole name, property acquired during the marriage with your income is community property. Generally speaking, property acquired during the marriage is considered community property unless it was acquired by gift, by inheritance, or was acquired solely by using separate property. The third myth is that a parent can be awarded sole custody in Texas. The term in Texas for decision-making powers concerning a child is conservatorship. The term regarding the child's visitation schedule is called a possession schedule in Texas. Texas law generally presumes that it's in the child's best interest for both of the child's parents to be appointed joint managing conservators, and that those parents should share in the decision-making powers concerning the child, such as invasive medical care and educational decisions. In order to rebut the legal presumption that favors joint managing conservatorship in Texas, the parent seeking sole managing conservatorship must show the court evidence of a reason, like substance abuse, family violence, or child abuse or neglect, that it would not be in the child's best interest for the parents to be appointed joint managing conservators. Even if a parent is appointed sole managing conservator, in most cases, the other parent will still be awarded a possession schedule and allowed to see the child. And this schedule may even be the standard possession order, which applies in a lot of cases of joint managing conservatorship. If you're contemplating divorce, instead of taking advice from family and friends, which may be inaccurate, it's important to consult with an experienced divorce attorney so you can avoid wasting time and money based upon common Texas legal myths. At Pruitt Law Group, we believe in educating our clients and empowering them to make sound decisions in their divorce case. If you're contemplating divorce, call us today to schedule a confidential consultation.